Hello, Brooke. How are you?
I'm well. How are you?
Okay, except for the fact that I learned recently from Mr. Lindley, sitting over there, that I'm a dinosaur and you might be as well.
Oh, no.
Yeah, yeah. Unfortunately, he was viewing something on, I don't know if it was on TV or YouTube, but there's now a computer that can do litigation.
I've heard of this.
And I haven't seen it yet, but the way that it was described to me is that the computer program will tell the litigant what to say in court, and so is based upon the sophisticated computer, and there's no need for us anymore.
We're out of a job soon.
I was thinking how that is going to work if anybody ever tries that, because of the fact that that computer's got to be damn good. It's got to know this judge, right? What happens if that judge is biased one way or the other, or leans one way or the other, or is so brand new to the bench that there's no background information to know?
Well, I think the problem, this is going to come back to haunt me in 5 years when they're doing our job, but it's almost acting as if litigation is just kind of like binary. It either is going to be a 0 or a 1, so you respond with either a 0 or a 1. Obviously, that's not how it works, I know, but it's kind of treating the courtroom like that, and unfortunately it's not like that. I wish it were. It would make our job easier, maybe too easy, but I agree with you. It'd have to be a very good computer to be able to read what the judge is saying, those emotional moments, the cues you get.
Here's what I was thinking. Let's just pretend that there's a robot sitting right next to the litigant. The litigant puts their chip in this thing, and suddenly it's their robot. Okay, let's just pretend that. And the robot has the ability of maybe leaning towards the litigant to whisper in the litigant's ear about what to do next, right?
Okay.
So they're hot and heavy on a case, and all of a sudden the robot's like, you should plead the fifth on this one, because or try to get to the judge's emotions, because this is the only appeal here.
It's all you have to the Hail Mary.
and how does the robot control the litigant? I mean, one of the things that we do, right, is that we, let me do the talking, And now litigants like to go in there, whether they're represented by attorneys or not, and sometimes they want to take over, right?
Definitely.
And they want to put ideas in the judge's head. And a lot of times, probably about 80% of the time, what is coming out of their mouth is something that they shouldn't say. That's why you have attorneys.
Yes.
You're there as an objective person to tell people, hey, that's not a good idea. Is the robot going to be doing that? And, maybe there's going to be like a, smoke coming out of its, ears or something like that.
It's going to get so frustrated.
Yeah, or a red light so the judge could see, that there's some problem. Or, Your Honor, I'd like to consult with my my robot here for a second, I mean, there's certain things that I can't see a machine or a robot, no matter how smart it is, replacing. And one thing is the art of practicing law. Yeah, there's citations of cases. I'm sure that there's lots of machines out there that are quicker than this old head right here,
Definitely.
right? But the art of practicing law is completely different. And I'm sure people are going to say, well, that's what they said about chess games, right? It's the art of playing chess. It's not just, and look at now the machines are better than humans, but it's not a mathematical equation, right?
No, I think the art comes in at the spontaneity of you responding to the judge, and you have to not make up arguments, but you have to pivot to new arguments. You have to, kind of hedge around things, protect your client. I don't know how a robot would do that, but I am also not the person programming these robots, so maybe
the robot could cross-examine the opposing party. They don't have a visual. Maybe it does. Maybe it comes with a camera. They could look at the witness and go, Your Honor, may take note that the witness is pointing up. I mean, it's going to have to be really, really sophisticated.
It's a bit very sophisticated, and then you're starting to get into that kind of scary zone. We just had that movie Megan come out, and that did not go well.
Oh my gosh. Okay. Well, I just suspect from this conversation that I'm probably not going to have to worry about this in my lifetime, but you may have to. You may have to find another occupation.
I'll be the person taking care of the robot.
Yeah, you'll be polishing it, plugging it in and stuff,
I'll be the setup.
Yeah. Your service to the clients will be, hey, we've got the best setup possible. The client will take care of you, or the robot will take care of you, but I'll take care of the robot.
So really, who's doing all the work? It's really comes down to me
There you
and
go.
my new job.
There you go. Okay, well, on a serious note, we're talking about a serious case today. What's the name of the case?
Featherstone v. Martinez with Hill.
Okay, now this is a 2023 published decision. It is the first one that we're going to cover this year. What is this case about in summary before you get into the facts?
This is a case about 271 sanctions. So in our case, the trial court ordered $10,000 in sanctions against mom and an additional $10,000 against mom's attorney, which is a lot. We don't see that. I have never seen that.
And when we say sanctions, people don't sometimes understand that means penalties. That means that like a fine, right?
And these are the 271 sanctions, which are kind of like really getting in trouble in terms of family law. You know, there's sometimes you get ordered to pay attorney's fees based off of, you know, income and things like that, but this is a penalty. This is a punishment.
It's meant to deter future bad behavior, and they're not doled out, you know, that easily in family court. But when somebody crosses the line, the court has discretion to order 271 sanctions. So what's this case all about?
Okay, so this is a parentage case. When the minor child was only 2 months old, mom goes in and files a paternity case. She asks for primary physical and joint legal custody, and she wants visitation to dad between 3 and 4 hours, you know, whenever he's in town, with 2 weeks' notice, and it has to take place at mom's house.
Okay, how old is this kid?
2 months.
Okay, so at first blush, it seems like it's not a reasonable thing to do, but I could tell you that I've seen a lot of courts order that. They're saying until the child's 6 months old, the child's going to stay with mom in the house, and dad, you're going to go to the house and spend lots of time, you know, in the living room.
Right.
Okay.
There's one more complicating factor, which dad agrees with. Dad is only in town about 3 or 4 times a month, so, you know, it kind of limits the sort of visitation schedule he can have. And then father responded, and he was only asking for 8-hour visitations, and he wants overnights to start when the child turns 6 months old.
A little early for a lot of courts. There's no magic time. You know, I've seen courts, believe it or not, I've seen a 50-50 arrangement when the baby was like an infant. I don't know where that judge is coming from, but normally courts are going to wait until the child turns about 1 year old before there's overnights. And the whole idea is that very important development and bonding that mom has with the child. Not to say that the father's not going to get a lot of face time with the child, but at overnights, it seems like 6 months is a little early.
Well, mom replied saying that essentially an agreement, but that overnight should start when the child is 2 years old.
Okay, now that's getting a little on the other side. Okay,
Definitely.
that's called trying to control.
Right.
Okay.
They have a hearing in December of 2019. Both parties are in pro per, but mom comes in asking for a continuance in order to get counsel. The court agrees to the continuance, but then wants to make some interim visitation orders. And this is when the judge starts to, well, I guess I'll let you decide what you think the judge is doing here. He talks to mom somewhat harshly.
There's some commentary that's
There's
going
some
along
commentary,
here, right?
yes.
He's already weighing in on how he feels about the case.
Exactly.
And what does he say?
He said, the way you wrote it, it was along the lines of, I control everything, I'm the boss, and, you know, I'll do him a favor and let him see his child. That's not how it works. You are co-equal parents. Moms get the advantage because technically, literally, when a child is born, they are there, obviously. But then when it comes to court,
I would
they
hope
think...
I hope they're there. I read that and I'm like, well, dude, come on.
But then when it comes to court, they think, well, I'm the mom, I always win. And this was what he said in response to mom saying that she was very open to allowing dad to see the child at any time.
Which, you know what, she may have been like a lot of young mothers that very guarded and stuff, and there's still some feelings for the relationship. But when you read that, and you remind me that was when she was requesting a continuance, and he wants to make orders. So he's like, you know what? Yeah, you go get an attorney, but I'm already going to make some orders that's going to impact you, rather than saying, I mean, what's the hurry? How old is this baby?
He can't be more than 4 months.
Okay, well, you know what? It could wait another month or something. You know, the father could wait another month for mom to have adequate counsel, but he starts blasting into her and commenting and changing and making orders right away.
Well, I also think, I've seen clients say, I'll just decide when dad can see the child. That's not what mom is saying when she says that she was open to allowing father to see the child at any time. She's saying that dad doesn't have a fixed schedule. He's here 3 or 4 days a month, and I'll let him come whenever he's here. You know, a normal standard visitation schedule isn't going to really work in this circumstance. Is I guess how I took it, but maybe I'm.
You know what? But you got to always remember how old the child was at that time. It's 4 months, and it's a young parent, and things change as it goes along. So was she being that ridiculous? No, not in light of what you just said. So.
Right. And the judge said, so it's not a lack of familiarity. You should literally be at 50-50, which I take issue with. And then he says, not I let him see whenever he wants to, but I guess he has a weird travel schedule. So really, first of all, the child's so young, it shouldn't be 50-50. And this isn't a normal situation where both parents live, you know, in the same area where you could do a 50-50. So he's like, I felt like he was setting this mom up for failure.
It should be 50-50. I missed that decision, or that code section. Yeah. So my understanding is it's the best interest of the child, right. And there's no way that the court should presume one way or the other.
This is a smaller thing, but at that same hearing, he asks her about breastfeeding, and before she can answer, he says, don't lie and don't exaggerate, which obviously we don't want our clients lying or exaggerating, but I do think it sends a message to have the judge say that to a mother, you know, the first time they're in court. It seems very clear that he is coming from a certain position. Yeah,
you know, you're assuming she's lying. You're assuming that it's appropriate to go on the attack, you know, rather than saying what you have to say, but showing, you know, some respect and giving the person dignity in the courtroom.
Right.
I mean, I see judges sometimes do that, where I think they lose the sense of what they're there for, and it's that power that they have. And I don't mean to be, you know, digging myself a hole with a local bench and everything like that, because there's some really, really great judges out there. But when they get into that preaching mode, you know, and start I know everything already. You know, when the case is brand new, I mean, there's a problem there.
Right.
Right.
The judge again says that it should be 50-50, even though the dad wasn't even asking for 50-50. And the dad had to speak up and remind him that he was just only asking for 1 weekend of visitation per month. So, you know, why is the judge being more aggressive than the dad?
Yeah, dad's probably panicking at this point. He says, I can't take that baby 50% of the time. I mean, come on. You know?
I want it. Yeah. And so then he does rule completely with the respondent.
Respondent being?
The dad.
Dad, okay.
I apologize. And he said, I think in the future, speaking to mom, you're going to have a really hard time because although I've tried to explain it emotionally, and I understand you do not feel like he's an equal parent and you feel like you need to drag this out and make it slow. This is the first hearing.
Wow. Can I say something about that? You said this is the first hearing. I think that sometimes it takes a good year for a judge really, if they're getting the case in little snippets like that. You know, it's not like they're sitting there for a long cause trial. You know, you come in, you have maybe 15 minutes, maybe an hour, and the judge decides, and you know, the judge won't see these parties again for another couple of months. It takes a while for the judge to really figure out the case, you know, but like that, you know, and that's the danger of people jumping to conclusions like that, you know.
I agree. The next hearing is in March 2020, so it must have been early March before everything changed. And mom has come in with an attorney, and they file a motion to disqualify the judge. Usually, you would think that might be untimely, but the judge raises this issue. But the mother's attorney says that she was only recently retained, and they had only received the transcript that same week of the hearing, so they had to wait for that to try to make any motions.
Which is probably incorrect, right? We're proceeding under 170.6 of the Civil Code of Procedure, which says that you get to object to the appointment of a judge. This was a judge, not a commissioner, right?
Yes.
Judge, but the rules say you have to do it within 15 days as to when that judge is assigned to the case.
Right.
So what we have is more than 15 days, but you got an attorney. The attorney's saying, well, I didn't have 15 days, and I had to get a copy of the transcript. I don't think that argument washes. Yeah. But the point is how did the judge react to that, right?
He did not take it well, and you can see it throughout the rest of the hearings. And he denies it, saying that it was untimely, and then quickly said during the hearing that mother's attorney was not directly answering the court's questions and warned that without improvement, they would start talking about sanctions.
So I don't like the way these conversations are going. I'm going to sanction you because you're talking and
trying to disqualify me.
Okay, interesting.
There are plenty more hearings, and at least 2 more, maybe 3, the judge would kind of make a record of the case at each hearing. And at each time he was doing that, he would describe the case in not great terms towards the mother.
But the case looked like it was headed in maybe a settlement mode at some point.
It was looking like it was going to be a settlement. When they were filing their trial briefs, father asks for $7,000 in sanctions based on mother's motion to disqualify the family court judge and her proposed judgment that did not correctly reflect the orders the court had made and her refusal to settle, which I think is interesting, and I'd like to come back to that in the future. So at one of the hearings, when the court is making a record of the case, he being the judge, emphasizes the early declaration from mom. He emphasized the motion for disqualification and said, she has the right to believe I was biased, but she always has that right, but I can't sanction her for that. Mother then argued that the 271 sanctions were not properly noticed, and then the court said that he thinks that he noticed the petitioner for sanctions on his own motion at one of the earlier hearings. That was at that second hearing we had talked about. That's another sadly something that isn't addressed by the court. They don't get into that.
Well, in a way it does, in a way it doesn't. But basically what he's saying is I gave you notice earlier on when I was giving warnings.
Right.
He was blowing smoke, and he was talking about, hey, I don't like the way that you're talking, and he presumed that was notice of 271 sanctions. The decision later on will talk about whether or not he could do that on his own, right? So
yeah, well, they actually never answer it. They bring it up and they mention it. Could he do this? I don't know if a judge can, notice motions on their own. But then they, spoiler alert, they decide to reverse the decision, so there are no sanctions, and they don't get into that point. But it's an interesting question.
Right.
They have another hearing. They're almost at the end. They almost have a settlement. The thing that is holding them up is that mom asks that the FaceTime or the video calls take place on Zoom because it can be recorded, and dad says that he wants it to be on any video call platform. The mom is very upfront with the court about, I wanted to be able to record, and then the court really goes
ballistic.
Says, there has been, and I have been concerned, and we will touch on that later, that despite all the good things petitioner, mom, has to offer, there has been a tone of control in this case. It started with the very first pleading. Mother's attorney immediately renews the motion to disqualify the judge on the basis of bias. The court then says it will temporarily move into a sanctions hearing and gives the case history. I think this is the third time. And he mentions he calls mother's request to record father's video calls offensive. He said mom has a controlling mindset. He said, I asking questions, making clear to both sides what my concerns are, and every time I attempt to do so, I'm 1, interrupted, and 2, accused. Later, the court said that the case was close to resolution and would have been a great opportunity for the court to give just the tiniest amount of sanctions, but now sanctions are thoroughly back on the table, and I am now accused of bias because I am concerned that your position might be a little overreaching and controlling.
Okay, I just have to tell you, maybe
Little
a
something.
salt shaker of the sanctions. I'm just going to sprinkle some sanctions there, but now everything's on the table.
Yeah, now we're bringing out.
Now we got
all
the
of
whole
it.
enchilada. Okay.
They then have, this is the last hearing, they have a sanctions hearing. The court starts off by saying that it's been noticed, re-noticed, and repeatedly noticed, again, based on him noticing it. And then, he gives another case history where he speaks aggressively about mom. He describes her moving papers, which one happened when this child was 2 months old. That's when she filed. She was in pro per. He says, in a vacuum, mother's second declaration was misleading, entitled, controlling, manipulative, and dismissive of any rights to meaningfully participate in co-parenting by father. The court deemed the request that the court prevent overnights for 2 years while limiting father to approximately 1/4 or 1/2 of 1% timeshare for those 2 years in and of itself sanctionable. And then the court declared that it was far too experienced to have moved in that direction without giving mom the real time and space to become familiar with the law and the real world practices of family court in California. So basically, he's coming down on mom and then patting himself on the back for giving her time to figure out the law, but it doesn't really seem like he is.
It sounds to me like he's advocating at this point.
Mm-hmm.
That doesn't sound like a judge talking. That sounds like he's on counsel table standing next to the father's attorney and going, and yeah, what about this, and stuff. Interesting. Before you go any further, I do want to say that it seems like the judge felt like he was being disrespected, that the court was being treated in a disrespectful way, and he was going to remedy the problem. The decision doesn't talk about this, but there is a remedy for that type of behavior, and it's called contempt of court. In those cases, that has to be set for a hearing. It's specified. There's notice for that, and it's usually a different judge that rules on the contempt. I think that's always
would make sense.
Yeah, and stuff. But he didn't go that route. He started saying this is sanctionable conduct because of how you're behaving in my courtroom. Mm-hmm. Okay, go ahead.
He said the motion to disqualify was untimely, and then the substance of the motion to disqualify was written out of context in an intentionally inflammatory and dishonest manner. It was altering the court statements, removing the portions wherein the court repeatedly expressed empathy toward the petitioner, mom, while presenting the now out of context aggressive sounding language as accurate and complete.
Wow.
Taking it a little bit personally, I think.
Yeah.
And then the court also did find issue with the issues within the judgment, but I want to be clear about what those issues were. It didn't specify that they were non-Montenegro orders. It didn't include a date at which time mother's tie-breaking authority would end. It misstated the temporary visitation. It didn't specify that there was joint legal custody. It misstated the child support by $70 and said that there had been additional child support when there wasn't.
So as you're reading that off, it's obvious to me that the judge was reading from husband's attorney's brief. Mm-hmm. That's what was happening.
It must have been, right. But interestingly, mom's attorney said that the child support issues that were or mistakes in the judgment were due to an inability to get information from father's attorney. That could be sanctionable. You're frustrating the settlement process, but the judge does not find any fault with that. And then on multiple occasions, the court mentioned its own empathy towards mom. We heard a little bit about that, and its lack of bias. I don't want to keep reading, but I just have to end with this. The judge called mom's request to record the telephone or the video calls alarming, outrageous, unbelievable, tone-deaf, counterproductive, and inconsistent with Family Code 271.
So I would say he could say all those things. It's just that he's attaching sanctions to them.
Right.
I mean, a judge could say whatever they want about it. That's what they're there for, is to describe what they're seeing. And maybe some of this stuff was true, but to start sanctioning somebody for having their day in court?
Well, and the request to record is interesting to me because, as we find out in the discussion, the court had asked them to record exchanges because there was some issue with certain things, one side saying certain things had been said and the other side saying they hadn't. So he asked them to record to prevent this from happening. So I don't think it's, mom going out on a limb to want to record the calls. Maybe the court doesn't want that. They want the special time between dad and child. That's fine. I understand. Don't make the ruling that it can be recorded. But, I don't think you can call it tone deaf
or sanctionable conduct.
Right. So that's the background. I know it was a lot. I wanted to start with sanctions against the attorney. This was reversed very quickly. The appellate court used the words obviously wrong because you cannot sanction an attorney under 271. If you look at 271B, sanctions shall be imposed only after notice to the party against whom the sanction is proposed to be imposed and opportunity for that party to be heard. And then if you look at 271C, an award of attorney's fees and costs as a sanction pursuant to this section is payable only from the property or income of the party against whom the sanction is imposed, except that the award may be against the sanctioned party's share of the community property. And then the court listed 3 cases which set the precedent. So it's very clear that you don't use 271 to sanction attorneys. That doesn't mean you can't sanction attorneys. You would just have to use Code of Civil Procedure section 128.5.
So I also remember from reading this is that the appellate court made very short, you know, work of the sanction against the attorney, because it said because an attorney may not be ordered to pay a sanction under 271, right?
Right.
The appellate court's order compelling the attorney to pay $10,000 was improper and must be reversed. That's all they had to say there.
Yeah.
Is that there's other codes where attorneys could be sanctioned, but not 271.
No, 271.
So, you know, okay, I mean,
It would have been nice to see what they would say about the conduct itself, if that would be sanctionable under the correct code. I still don't think it would be.
I don't think it would be either.
But yeah, they didn't have to get into that discussion. The sanctions against Mother, obviously, that discussion took more time, but it was still, they started off pretty strongly. I think they said something, it's also wrong in reverse, although maybe not as obviously wrong. So they go through why the sanctions were given, and that was because of Mother's early declarations in the case, the motion to disqualify.
So I'm going to sanction you for filing a motion to disqualify me. Okay, go ahead.
Her proposed judgment, and then the video call recording request. I really liked this sentence. Threaded throughout the court's recitation were 1, the court's characterization of Mother's request as entitled, controlling, and overreacting, and 2, its own umbrage at being accused of bias and being the subject of a disqualification motion. Individually or collectively, this is not litigation behavior that a judge staying within the bounds of reason could conclude merited sanctions at all, much less at $20,000. They used the bounds of reason assessment from Goodman v. Lozano, which sounds like an interesting case to read.
Yeah.
And then the appellate court becomes even more explicit, saying the court was principally sanctioning Mother for not taking action that frustrated the settlement efforts, but for taking litigation positions which the court disagreed. Which I thought was pretty interesting. You know, when we talk about 271 sanctions and frustrating the settlement efforts, you know, sometimes I think that line between settlement or frustrating the efforts and actually taking litigation positions, it can, you know, it's kind of a gray area maybe, or it could be.
Well, that's worthy of this discussion here. I once did a very lengthy trial in front of one of my favorite judges, Judge Mary Nelson, who I don't think she's on family law bench now anymore. But I was asking for sanctions because of the issue that was raised by the other side that I thought was meritless during the time of the trial. And she turned to me and she said, Mr. Schweitzer, do you think that people don't have, that they should be sanctioned for raising issues that they ended up losing on? And I was kind of flat-footed. I'm like, well, no, of course, because people do that all the time.
Right.
I think 271 goes beyond that. 271 is where you're obstructing the public policy to work towards settlement, and you're doing things that are completely contrary to the spirit of the law of giving people their, you know, due process rights and, you know, bringing something to a conclusion, you know, in a way. It doesn't mean that you can't litigate. 271 wasn't meant to stifle people in court, right?
Right.
You know, and I think you and I covered a case recently in 2022 where the person was using up a lot of the court time, 5 days of court time, and you know, as it turned out, the litigation tactics were silly, such as making the other side prove that it was his signature and then agreeing to it after
Right.
that, right? Now, that's a different issue because he was asking for attorney's fees, and the court said, well, you know what, you're not going to get attorney's fees because you were taking a position that the litigation strategy was not necessary. So you're talking about that fine line, you know, versus, you know, when somebody should be punished basically for doing something that's contrary. I think it's a level above.
I think you're
and
right.
in this case, what was Mom doing? I mean, she was basically, you know, doing what you see in family court every single day. You know, maybe taking a hardened position about father visiting with the kid, but that's what the judge is there for, right?
Well, we also see people take that hard position in the beginning, and I don't think you can fault people for that. They're
Right.
not, you know, aware of how the courts, you know, usually decide these things, what California law is. You know, it's not 50-50 always, but it is the best interest of the child. They don't know the factors that the court looks at, and you can't, you can't hold it against someone, I don't think, for not understanding how California custody works.
Yeah. Or let's say that you goof up, and in this case, there's a request to remove the judge 170.6. I don't want to stipulate to this judge, or I want to go somewhere else, and you get the timing wrong. Is that sanctionable? Or you file something that's a little bit late. Is that sanctionable? No. It means that you don't get the relief that you wanted. That's what happens there.
I mean, it may be sanctionable when the robots are taking our jobs, because they should really be on those deadlines.
Yeah.
The appellate court also found that the trial court ordered sanctions partially based on mothers seeking disqualification of a judge, and the judge admits that petitioner had the right to believe I was biased. She always had that right, and I can't sanction her for that. The court said that. The trial court said that originally, but then the appeals court points out that the record reveals the court was unable to hold to that standard and did what it said it could not by improperly relying on mother's disqualification motion and renewed objection to impose sanctions. On that one, the judge.
Yeah, and here's a great quote I put is, one cannot read this appellate record without coming away with the impression that the family court was just miffed about the accused being accused of bias. On a personal level, that is understandable, but exercise of the judicial function requires more, and the mere accusation of bias here is not a reason for a five-figure sanction, or any sanction for that matter. I mean, that's very strong language from a court of appeal.
Oh, definitely. Then they talked about the proposed judgment issues, and they said the particular errors were not so significant to merit sanctions in any way. We do judgments all the time, and there are little things that slip through, or little mistakes that you just work to correct. It's not out of this world for that to happen. They then talked about the request to record, and they talked about how the family court itself had previously encouraged recording in a different circumstance. And then going back, this is actually what they say after the great line you just read. Substantively, the filing of a motion is generally not sanctionable under 271 unless it is so devoid of merit that no reasonable person would have pursued it. And I think looking at the record, a lot of us would walk away thinking that there's some potential bias from the judge.
Yeah, so let's talk a little bit about that. That's a very important thing for people that are not attorneys. They want to go into family court and they want to file motions. You could be sanctioned for filing a frivolous motion, that is completely frivolous, right? I'm trying to think of an example of that. I guess it would be like, it's hard to even imagine, but I guess one would be if you want the other person to pay you spousal support, and you're like a gazillionaire, and that person's on welfare, and you want spousal support.
Right.
You're just doing it to harass and drag somebody to come in. I
And
mean,
it
that's
is
an
hard
extreme
to,
example.
it's hard
but,
to think of one for just filing a motion.
But there could be things where the court's already told you no, like 3 times.
Oh, right.
And you keep coming in with it, and then you know what, I'm going to sanction you for that.
Right. And so the court, agreeing with what I said the statements at the first hearing suggested that the court was allowing an apparent view of how mothers generally act, and that's not frivolous to think that he might be biased. I mean, I agree with what they're saying completely. At that first hearing, I couldn't imagine having been the mother, and just, it's already so nerve-wracking to be in court, especially the first time you have this young child.
Yeah.
And then looking at the early declarations, the court again said, the declarations were not devoid of merit. The father was only around 3 to 4 days. It was a newborn. He hadn't had any overnights. And the court often makes an argument about consistency with visitation, and that goes along with what mother was saying. It's not devoid of merit. There's a lot of merit there.
Yeah. Well, let's kind of step back from this case a little bit and talk about what goes on in family court with regard to this stuff. And a frustration that I have on occasion is when a judge makes up his or her mind without really giving you your due chance to explain things and stuff. And the judges are overloaded with cases. There's no doubt. They see patterns just like we do. Most of the time, they probably get it right. But sometimes when you're in front of a judge and the judge is just completely giving you the stiff arm and won't let you talk, that's very frustrating, and stuff. I had one case where I was trying to be an advocate for my client, and I was standing up arguing. The judge didn't like what I was saying. And he started yelling at me, and he told me to sit down, Mr. Schweitzer. So I slowly sat down, but I continued arguing, and I argued even more vehemently, as I was sat in my chair and stuff, because the thing is that they shouldn't be stifling you. I mean, especially an attorney. An attorney's job is to advocate. It's not to be a jerk. You have to be respectful for the court and the judge. But your job there is to put your client's best foot forward, and stuff. And in this case, you had a young mother who in pro per didn't have a clue as to what she's doing. So there's got to be some allowances for that. Then she comes in with an attorney, and at that point, sanctioning her, and we already know that the sanction for the attorney is not appropriate, but sanctioning her for, taking positions that aren't all that crazy and stuff, so.
Well, and it's interesting because the first hearing, the December 2019 hearing, the order was not that far off from what Mom had said. She wanted 3 to 4 hours at her house. I think it became 8 hours at Dad's. It's not, like they did the,
right.
50-50. They couldn't do the 50-50, which is why Mom wasn't asking for it, potentially. This could be a mom who was having some control issues, perhaps, but when you look at what she was actually asking for and the situation, it's not a crazy request.
Yeah. I think, how do we use this decision in our practice? I guess one is if you're confronted with a case where a judge is going to be issuing sanctions, make sure you read the code and see whether or not it's even appropriate.
Right.
In this case, we learned that you can't sanction an attorney under 271. And this could be a great case, I think, for citing if it seems like the reasoning is off, right? I think it's also a good lesson for younger attorneys to know that your job is to go in there and still advocate, and it's completely against, what we stand for, our Constitution, our belief in due process, to be completely stifled and be sanctioned because you are exercising your right to say, hey, I'm not going to be in front of you, Judge. I was just in court 2 days ago, and the case has been going on for 3 years. There's a contempt that's filed against the other side. A public defender comes in. Public defender very politely tells the judge, I'm going to be exercising a 170.6, which means I'm going to be exercising my right not to be in front of you,
right,
because she knows, some of the history of the case and everything. And it was done very, very professionally. The judge was like, okay, let's set a hearing and stuff like that. And there were no overt hard feelings about it or
right,
anything like that.
Well, it's not personal.
Right.
I also thought this case would be an interesting jumping off point to talk about transcripts. This case relied very heavily on the transcripts of all of the hearings.
Oh, yeah.
And I'm not sure if our viewers are aware, but right now in family court, we do not, in LA County, we do not have
court reporters.
Court reporters. I apologize. And so what would have happened in this case if there had been no court reporters?
Yeah.
How would they have made a decision?
One thing about the court reporter system that's kind of interesting right now, I'm almost feeling like there's some politics going on, because they'll tell you, well, we're going to have a court reporter today. So the fairy godmother has just come into the court,
right,
and you have it, right? But you don't have any control over that. So if you absolutely have to have one, you hire your own. You prepay the money, and then your court reporter shows up, and it's like, hey, guess what? We got one for the courtroom.
Right.
It's crazy right now with regard to that. And we covered this in a prior podcast, but the court has made it known. I think it was like in November of 2022 that there was going to be no court reporters, in family court anymore. And then they said, well, we'll have them for domestic violence cases. But the reasoning was supposedly because there weren't enough court reporters, because people aren't taking on those jobs anymore. I just wonder if there's been some kind of wage issue or something like that, because it just doesn't make sense to me.
Doesn't make a lot of sense to me either.
Yeah. So anyways, if you get into a situation like that and there's no record, it's hard to defend yourself against what a court might say in a statement of decision or
Right.
something, right? Yeah.
Yeah, it would be impossible.
Okay, well, keep fighting, kid. Thank you very much for joining us. Brooke did a great job. We look forward to seeing you next time.
Yes.
Okay, and we'll see you next time as well. Thank you.